Thanks to Mark and Andrew and Eamon for coming in, and sorry for the delays with the voting. I want to maybe start with the last point you made, Andrew, which is that you'd like us to maybe think about or consider increasing the cap, which is, I suppose, the level of investment that the state is willing to put into films. And I would be very, very happy to be agitating for increased investment. And in general, I am very much in favour of us spending more on arts, cultural endeavour and film. I think we don't spend enough. But, and I'm sure you're aware of this, my enthusiasm for arguing for those things would be considerably blunted by my concerns over the extent to which the film producer companies, such as yours, that are in receipt of Section 481 are complying with the requirement for quality employment and training as set out in the legislation, and indeed as is required under EU state aid rules, which are very clear that there's a requirement to meet an industry development test and there's a requirement to meet a cultural test. And part of that industry development test is precisely to have quality employment and training. And indeed, the EU directive is even more specific. I'll paraphrase it, but it's about creating a permanent pool of skills. And it uses that sort of phraseology, permanent pool of skills. Now, my concern is that it's not doing that at all. That it is instead what's happening, and it's summed up in your initial introduction, with the idea that it's a freelance industry. So it's not permanent, it's freelance, it's project to project. So very few, if any, people have any kind of security as to their place in the industry. And that the producer companies, for some reason, which I don't understand, insist that they don't want to give any rights to employees to have a sort of legitimate expectation from one production to another that they will be employed in the future. And I mean, I don't see, first of all, why the producer companies want to insist on that position. I don't see how it's beneficial to the creation of an industry and the growth of that industry. Because surely developing and nurturing your crew and giving them security would be good for the industry. It would be good for attracting more investment. It would just be better at every level for the cohesion, the skill, the expertise of the industry, is to give people a bit of security from production to production. But instead, it seems that the producer companies, including yours, insist trenchantly that they don't even have an employment relationship with the people who work with them again and again and again and again. Now, tell me if I'm wrong, but my understanding is that this is precisely what's going on, is that if you list out some of the things that you've listed out there, there would have been crew members who would have worked on multiple of those things that you've named, one after the other, going right back to when you were set up, probably in 2001, again and again and again. And yet, when those people seek to assert that they have some rights, and indeed they would argue, and I would agree with them, that under the fixed-term workers, and you referred to fixed-term workers legislation, that they have those rights by law and under European Union directive, that they have them, but yet the producer companies want to insist that they don't have any employees who are entitled to such contracts of indefinite duration. And I want to stress that nobody is suggesting that that means you would employ them permanently, full-time, 365 days. Nobody's arguing that, but that they would have an expectation if they'd worked on, let's say, Ripper Street 1, Ripper Street 2, Ripper Street 3, Ripper Street 4, that the next time Element Pictures was making a film, that they would have a legitimate expectation and indeed a right to be re-employed, to be notified, you're making a film, you worked on my last few films, and therefore I'm letting you now know that there's a job available for you on the next film. But instead, you insist that you have no obligation to them, and indeed when those employees take cases to the Labour Court of the WRC, and I won't go into individual cases, but in general, the response of the film producer companies is to deny any employment relationship whatsoever with these people, even though they know them. They know them, they know they've worked on the films that you've named there and the TV series, but they say, I don't have an employment relationship with you, you only have an employment relationship with a DAC that now no longer exists. So I just want to understand why you'd want to do that. I would put it to you that that is in breach of the fixed term workers legislation, the whole purpose of which is to prevent the abuse of successive fixed term contracts. That's the whole point of the legislation, is to say that you cannot keep employing people again and again and again, the same people, on fixed term workers, fixed term contracts. But if you keep employing them again and again and again, you start to have an obligation to them as an employer. So, yeah, I would ask you why you'd want to do that. Just one thing that I wasn't even aware, but I was looking at the guidelines of Section 481, and very specifically, Section 481, this was a bit I wasn't aware of, actually says that the producer company, not the DAC, the producer company is allowed to charge the cost of full-time employees to the DAC. You're allowed to do it, and it specifically uses the word film crew. Now, I presume you do charge for some of your admin employees to the DAC, and Section 481 pays for that. But yet you don't want to do it for film crew, even though they are explicitly mentioned in the Section 481 guidelines as somebody that you could charge to Section 481 under the DAC. You could charge and have them as employees. So, I mean, that's quite a long question, but you get the point. I would appreciate an answer. I do want to ask, now maybe I should do this separately or do them all together. I want to ask about the intellectual property end of things.
Question and then we'll go back to Deputy Farrell.
So add in that question. Okay, so then there's the actors and performers. And, their creative work, obviously, is one of the things that's valuable about films from a commercial and financial point of view. And I think it's fair to say that the way films potentially make any money is through the royalties, if you like, the flow from the distribution and the performance of those films or TV series again and again, or they're downloading on Netflix or whatever it is, right? So it's not at the time when the DAC is set up for the production that money is made. The money is made on the basis of those things being shown again and again and again. But while the DAC is set up, the producer companies are insisting that the actors and performers assign their intellectual property, their rights to the intellectual property, to the DAC, and that their rights to future royalties or residuals are bought out from them in a contract that is significantly inferior in this regard to the pact equity agreement that operates in the UK. And indeed, the sort of inequality in this regard is even more stark when you find that some people are put on the pact equity agreement, but other people aren't. Or that if Element is operating in the UK, or Element or any other company, for example, you have to work the pact equity agreement, and the performers get the benefits of getting a better deal in terms of their intellectual property and the residuals that would flow to it. But when they work in Ireland, or many of them when they work in Ireland, there's an insistence that they saw in these grossly inferior buyout contracts and sign away their rights. Why? Why would we do that to our performers? And indeed, where do those rights then go? Because while as the producer companies insist that the employment relationship between film producers and crew does not survive the DAC, to use the parlance, they also seem to have it both ways, because the benefit of the intellectual property rights does survive the DAC. Where it goes somewhere, where does it go? If when the DAC is wound up, I mean, for example, why, when the DAC is wound up, do the intellectual property rights not go back to the performers? Where do they go? Do they go to the producer company? Do they go to an international company? Did the people who signed it over to the DAC agree to sign it to an international company, which they are required to do? But why, indeed, are we being asked are they being asked to sign these buyout contracts when the Copyright Directive insists that buyout contracts should be the exception and not the rule, and yet in Ireland they seem to be the rule and not the exception?
Okay, we allow our witnesses to come back on some of that.
Okay. Thank you, Deputy, for that question. It's obviously multifaceted, and I will do my best to try and
I apologise for the length of it, by the way.
On all aspects of it, and you no doubt will remind me if I've missed anything that you need me to elaborate on. And I'm sure Mark and Emer will want to kind of feed in too. I mean, there's a couple of aspects, and what I might start with. And hopefully, as I say, cover everything you've asked me, is the recruitment process and the employee relationship, and the right to be re-employed that you referred to. I mean, the reality is, on each and every project, we recruit on the basis of the skills required for the job, and that's the primary consideration. And that goes right up and down the chain, so to speak. So we will start, I described earlier, we develop the project with a writer, and then we attach a director, and with that director, we will identify the key creative heads of department that they want to work with, that director wants to work with. And so typically, a director will choose a production designer, who in turn will have a particular construction manager they feel is appropriate for the job, depending on the nature of the job, whether it's contemporary, whether it's a big period piece, and so on and so forth. And you know, costume designer will do the same, and they will build their teams, and those teams are chosen on the basis of the skills required for that particular job. The situation you described, where why wouldn't you just use the same people on every film, is just impractical, even if it were desirable, on the basis that crew, you know, chop and change and go. They follow the work they're most interested in. They don't decide I'm an element person or I'm another company person. I only work on their projects. They really want to work with the most interesting directors who attract the most interesting cast, and those are the projects they're most drawn to, and that's primarily the consideration from a crew point of view. And I think it's, I mean, I know that, you know, you've had testimony from other organisations representing crew, and indeed the WRC did an audit of work practices in the sector, and talked at some length about the point that the crew themselves were telling the WRC they want to remain freelance. Freelance suits them because that allows them maximum flexibility to choose who they work for. And it's, as I described earlier, the industry is organised globally on that level. Every single country in the world operates in the way that I've described. There isn't a single country in the world that operates in the way that you're suggesting. And that isn't because there's some, you know, global, you know, sort of scheme to disadvantage workers. It's just the way the industry has evolved and the nature of the industry. It is project-specific work. People commit to doing it. It's very intense, hard work. And people tend to come onto a film or television series see it through, and then they may take time out, or you know they'll switch and they'll do something completely different, or you know, so not everyone works full time in the industry all year round. Anyway, they've got other things going on. So there's a multitude of factors at play, and so from our point of view, you know, you talked about the EU directive and the obligation to create a permanent pool. You know, I don't think that's contradicted by the freelance nature of our industry, because you know, freelance and permanent are not mutually exclusive. We have a permanent pool of freelance crew who work in the industry, and for me personally, the best evidence of that is people I started out with 25, 30 years ago working in the industry when I used to work in crew are still there, and they're all senior heads of department at this stage. They are the permanent pool of crew who have been created, you know, in an industry that didn't exist 30 years ago. Before we had 481 and Section 35, we had no industry in this country. So Section 481 and its predecessor, Section 35, has helped create an industry here with a permanent pool of freelance crew who are working happily on different productions for different companies at different times. And so the, and again, the, you know, I would suggest the development test requires us to provide quality employment, not full-time jobs, not civil service type job for life, but quality employment. So it's fixed term, project-based work, and the important thing is that for the period that people are employed by us, they experience quality employment, and they experience career progression, and they get training where that's required, and they're well paid for the work that they do, and they have satisfying work, and at the end of the employment they have a credit that helps build their career and build their CV and helps open doors for future employment. And all of those things are in place, and that has been a collective collaborative effort from production companies and from agencies that work in the sector, and as a result of the amendments made in this House by you and your colleagues and government in terms of amendments to 481 over the years. Just in terms of the DACs, again, you know, the DAC is a commercial necessity. It predates 481, it predates Section 35. It's a standard business practice, whether you're making a film or building a bridge with multiple parties involved in financing and building it. DACs are a vehicle through which all the resources of that project can be funneled and all the people working on that project can be engaged. And it's not, however, correct to say that as a director in a DAC that we would ever turn around and say to someone, well, sorry, your employment rights, it doesn't matter about your employment rights because the DAC is gone. I mean, we, as the production company, we deal with, sometimes have queries from people 6, 7, 8, 10 years ago say, can you dig out a copy of my P45, for example? We don't say, well, the DAC is gone. We go out to a warehouse, pull the files, we find the copy of the document and send it on to them. So, you know, the period of time that people are employed by the DAC, they have all their rights. And in the event that they have an issue, they have recourse to the industrial relations mechanism, same as any other employee in the state. And we have been involved in labour relations, WRC and Labour Court hearings from time to time for companies that are no longer active, but we go along anyway to provide information and share and respond on behalf of that DAC. So I don't believe there's any evidence of any systematic problem in the WRC, the Labour Court, with respect to dormant DACs or struck off DACs. I'm happy to be corrected on that, but that's my personal experience.
Andrew, can I just, can I?
Okay,
sure.
Yeah, you can make your point and then I'm going to bring in Deputy Farrell.
Just on that point though, I mean, in cases that have happened in the Labour Court, Element have gone in, as have SPI, and said no employment relationship can exist between us because the relationship is with the DAC. I mean, I've seen transcripts where the companies are saying that. They're saying the relationship is with the DAC. And I would point out that all of the employment legislation, all, Fixed Term Workers Act, the Redundancy Act, you name it, makes clear that the companies that are associated with each other will be treated as the same company. And you're not disputing, surely, are you, that the DAC you set up for any given film is not a subsidiary of of Element, because they are, legally speaking, they're a subsidiary of Element.
Yeah, we're not suggesting that we've nothing to do with the DAX, Deputy. Obviously, as I've said in my opening statement, we incorporate the DAX in order to shoot the film or shoot the television series, and all the financing and all the production expenditure goes through that DAC. And that is the case. The DAC offers employment to freelance crew for a fixed period of time because that's all it's required to do. It's required to spend 8 weeks shooting a film or 6 months shooting a television series, and we plan accordingly how many people we're going to need for how long, and we raise that finance to pay for all those people. And once that show is done and we've done what we said we'd do and delivered, there's no money left and there's no crew left. It's finished and it is complete insofar as it goes. That's not to say the project is finished and complete and there isn't an ongoing responsibility from us as producers to administer the project in all its guises, including any employee-related queries that may be specific to the DAC, but which we're happy to deal with, and we do. So, there is nothing inconsistent between what I've just said and saying Element Pictures doesn't directly employ production crew, because we don't. The DACs employ the production crew, and that is a fact. And that's why DACs exist, because they're there for as the name on the tin says, they are designated activity companies. They're there for a specific purpose.
From an employment rights point of view, there's no difference.
Well, okay. Sorry, you finish your point. Sorry.
Just from an employee, like, I'm not a lawyer, Deputy, and obviously to the extent that if what you say is true, then obviously there's recourse to the WRC and the Labour Court to argue that point. My experience to date is that none of those arguments have been substantiated in practice in the WRC, the Labour Court, because I believe the legislation is more nuanced than perhaps you've just suggested there.
Okay, Deputy Farrell?